Hi, I'm Russ Weninger. I'm a wills and estate planning lawyer in Calgary, Alberta, Canada. Today I'm going to go over some of the more common estate distributions. It should be noted that the following suggestions are not rules set in stone. I intend these opinions to be food for thought. Your circumstances may require a departure from the following proposals. Probably the most common thing to do is to leave everything to your spouse or partner. This is especially true if it is your first marriage or common law partnership, or your first marriage or common law partnership involving children. If your children are young, if something happens to you, your spouse may have the sole responsibility of parenting your children to adulthood. If your children are older, they will in most cases be able to support themselves throughout adulthood, but your spouse will remain a life partner and in a very real sense, an economic partner. There are always exceptions, but in most cases, a spouse should be prioritized in a will over children. Furthermore, if your spouse inherits from you, they are likely to leave their estate to your shared children. If you are divorced or separated from your spouse or partner, or if your spouse or partner has already died, you may wish to consider leaving everything in equal shares to your children. Children may in some cases include stepchildren. If a child has died before you, but that child had children of their own, you may wish to consider giving the share that would have gone to your deceased child instead to your deceased child's surviving children. In a second marriage involving children from a previous relationship, a common thing to do is to leave something to your spouse or partner as well as something to your children. These may not necessarily be equal distributions. If you have had a relationship with your current spouse or partner that spans several decades, you may wish to leave that person the bulk of your estate. On the other hand, if the second relationship occurs later in life, you may consider it appropriate to give your children a larger share. If you are in a marriage or common law relationship, you may also wish to consider what should happen if your spouse or partner and children have all died before you, or at the same time as you, say in a house fire or car accident. This sort of provision is sometimes morbidly called a wipeout clause. Typical wipeout clauses have half going to your side of the family, usually parents or siblings, and half going to your partner's side of the family. If you aren't in a committed relationship and you have no children, it's common to leave your estate to your parents or siblings. In some cases, people will even leave their estates to their nieces and nephews or their cousins. Charities could also be considered as possible beneficiaries. Please check out my upcoming video in which I will talk about asset distribution that may occur outside of a person's estate. If you enjoyed this video, please feel free to like it or share it or subscribe to my channel. If you have a question, please leave it in the comments section and I will do my best to respond. While I don't want to give specific legal advice in the comments section, I will try my best to answer general questions, provided it is understood that my responses to comments should not be taken as legal advice, that social media interactions are not considered lawyer-client interactions, and that your safest course of action is to consult directly with me or another lawyer if you have a legal issue or would like to prepare a will. Thank you.